On January 10th, the U.S. Supreme Court heard the consolidated cases Washington v. WEA and Davenport v. WEA. The key issue in this case is whether the free speech rights of a union, such as the National Education Association, supersede the free speech rights of individuals as guaranteed under the U.S. Constitution. This case is the result of decades worth of investigation and litigation brought by the Evergreen Freedom Foundation, a Washington state think tank.
But most importantly, I wanted to thank Bob Williams and the Evergreen Freedom Foundation and the National Right to Work Committee for continuing this fight.
We're literally 12 hours away from oral arguments at the U.S. Supreme Court.
On behalf of the state of Washington, I want to thank the Evergreen Freedom Foundation and all of these teachers who are here today, because this case arose and the issue was brought to light because teachers stepped forward who had not joined the union and said, we believe that the WEA ought to follow the law and ought to have our permission before they can spend our money for political purposes.
Well, we're very pleased with the court today and the questions it asked of the union in particular.
There's no reason why these people should have to go out of their way, take time out of their teaching schedule to have to fight for their own First Amendment rights.
It's our opinion that too many teacher unions have developed an unhealthy sense of entitlement to teachers' personal finances.
My name is Steve Hinman, and I'm from Aurora, Colorado, and thought the arguments went very well in the court case today, and I really felt like all of the judges seemed to really be on our side.
We think that non-members, as they said today in argument, shouldn't be asked to opt out twice. They've already said no to the union. They've already said when they declined to join the union, we don't want any part of this. Why do they have to then go back and go through this whole arduous process of opting out again? No means no, effectively. The justices today were very, very unsympathetic, in fact, to the unions. They really felt like they had a lot of sympathy for Washington State and the ballot process, and they had a lot of state for these non-teacher members of the union who essentially, and Antonin Scalia kept using the word, had their money sort of forcefully extracted from them, against their wills.
remind you, in Washington State Court, the union argued successfully that they have no fiduciary responsibility to yours. And that's what was some of the interesting questions today. The union treats the money as theirs, even though you're supposed to get a refund. It's not theirs, it's your money, you know? And that's the whole issue.
Not only is this about us, it's about our students and their protection and about their First Amendment rights, so that it doesn't just stop with us. We're fighting for that next generation, and I think if we don't model that for them, how can we ever expect them to stand up and fight for them as well? Because it could be our rights that they're fighting for when we no longer have a voice.